Good?
Yeah.
Okay. So actually, I'm coming to discuss a topic, but I really want to hear from your end also what secular law has to do with this topic as well. Someone just asked me on Friday, someone, a Floridian resident, he went into a non-compete, entered a non-compete with a certain company. He now was laid off, quit, had a run-in with the owner. Let's just call it a misunderstanding. They just started working. He's working there only for a short period of time, maybe 2 months, and there was a certain understanding of how he's going to be paid, a certain commission-based pay. And then when it came time, when he landed a deal and supposed to get a commission, the owner said, no, it means something else. So there was a misunderstanding, they parted ways, and now he would like to stay in the same industry, but now he's faced with his non-compete. That was the question. So I'm curious to know what secular law in Florida has. I know in general we frown upon non-competes, and especially about a year ago we knocked down many of the non-competes. I don't know what Florida did, but where are we holding in Florida about non-competes?
It's also limited. It has to be a protectable business interest, though. That's one of the ways the court's limited also. Besides the fact that it has to be reasonable at the time.
Right, time and region.
Not any business interest. It has to be whatever they call legitimate business interest, like something that gives you a competitive edge. As opposed to just, well, this is my business, this is your same business, but if it's something that gives you a competitive edge, that's something like that.
So it means that only if he goes into that niche, you're saying?
Something like that, yeah. Exactly.
Also, they have different time periods for reasonable depending upon the relationship, whether you are a partner, or employee, an independent contractor. It may affect the duration and the geographic limitation.
Okay, that's good. And then you have the next level, which is related, is non-solicitation. Not to go to my clients and not to do all that. Where do we stand in secular about non-solicitation? That's enforceable.
Yeah, like to go, the solicitation of clients or of employees? Because usually
All of the above. Because usually most agreements, I mean, you know better, but most agreements we tackle everything. We get clients, we get employees, we get the other end as well. If not law firm, but you have, let's say, wholesalers or manufacturers. When I write a non-compete, I have like a litany of 20 items that, just in case, we'll get you anywhere you can get.
I think it's usually enforceable unless it's like a widely known employee.
Well, legal is the only exception. The legal industry is the only exception where it's actually by law. You are allowed to solicit clients.
You are allowed to?
Because the client is the boss of the relationship. So you can't say that I own this client. The client is the boss.
So even if you write a non-solicitation, it doesn't work. It's thrown out.
Still ultimately,
its
let's say somebody has a client and they want to follow an attorney when he leaves a firm. The client is the absolute boss. You can't control the client at all.
Okay, that's
On a
nice.
patient and doctor?
Why is it different than any other, than any manufacturer, any other relationship?
We're like a fiduciary, so it's the relationship. You can't say keep me as your fiduciary, as your trusted champion. If you trust someone else, you trust someone else. It's not. You can't force.
Whereas any other business is not like that. It's not fiduciary.
Yeah, maybe in the same way.
If you're a salesman for Prince, you go to somewhere else, and your clients want to deal with you, and they want to deal with somebody else.
Yeah, but again, that's not fiduciary. That's more relationship.
It's also because attorneys know how to do business for themselves, and they make the laws, they make the
I don't know. Is that beneficial for attorneys that they can take other people's clients, or is it harmful that they're losing clients? Which
Depends from which side. Yeah.
right?
If
So-
you own the firm, it's good that they can't,
attorneys generally
No, that
think
is
are
bad.
high opinions of themselves, so they always think that it's in their favor to be able
Uh-huh.
to solicit it.
Okay, that's a good point. Okay, maybe. Okay, so I want to discuss it from a halakhic perspective and take it apart, and then we'll talk about creative ways how to deal with it. But in halacha, unlike secular law, but in halacha, we throw out non-competes on its face. Means, by secular law, it sounds like really you could have this. It just, since it's harmful, it doesn't promote whatever it is, enterprise, whatever, they have other reasons why they want to knock it down or limit it. But in halacha, it doesn't work. It's not binding. And the reason why it's not binding is because you can't obligate somebody to do or not to do something that's not attached to an item or money. So I could sell you my house. I could buy an item. I could, assign an item, transfer an item. I could even create an obligation on myself that I owe you money. But to say that I want to make with you an effective, we call a kinyan, I never say kinyan in English, but that will stop me from crossing the street, I want to obligate myself that I'm not going to cross the street today. There's no such thing. You can't do that. Or I will cross the street today. You can't do that. It's what we call a davar shalom b'olam or davar she'ein bo mamish. It has no, I don't know, maboshes. How do you say maboshes?
Tangible?
It's nothing tangible. So what was it on? There's nothing that it's on.
Services though are not tangible all the time.
It's me. So it's my Maisi Dime. It's me. I could make it means if you work for me or I want to hire you to be an employee, so then yes, then your work could be for me. But to enter into an agreement that prevents you or obligates you to do or not to do something is not binding in halacha. There's no kinyan, there's no mechanism that can make it binding. So on the face of it, without any reasons, to promote business, we don't have to think about the greater public interest. It just doesn't work. There's nothing to make it binding.
Well, why is it you're allowed to obligate someone to do something, you just can't obligate that same person not to do something?
To not to do something, for sure you can't, and even to do something, it has to be in more like an employee type of relationship. So it means, because if I hire an employee, that means, let's say he's a 9 to 5. So that means his Maisi Yadayim means the work that comes out of his hands. Literally translated, again, I don't have a perfect translation, anyone wants to help me here, but it means, so his time, that 9 to 5, he's going to be working for me and everything that he does is for my benefit. That I could do. But to just arbitrarily say, okay, you have to sit still and not cross the street today, or even if I tell you you have to cross the street today, but I'm not paying you to cross the street today. I just want to obligate you that you got to do something that has no tangible, there's no item that does not work in halacha.
And can you always just attach money to it and then make it a tanai?
So that's how we get around this. But all secular non-competes never do that.
Well, in secular, the contract, you can't obligate someone to go across the street either. There has to be consideration in a contract.
But even the consideration, like in exchange for the $10, acknowledge, right? But there, you got $10, and then what are you doing? You're obligating the person not to cross the street. But in the halacha, not to cross the street is not an item. It's nothing tangible. So it's even if you pay me money not to cross the street, it won't work.
So how does non-compete compare to hasagas gvul?
So hasagas gvul, so just for hasagas gvul means where if I have a store in a certain area, I have certain rights to prevent a second store to come in to compete. That's not contractual. I never had any relationship with that other person, but the reason why it is because I recognize that if there's not enough business in the area, it's two ways, but I'm going to do it one way, to support two stores, so whoever's first sort of has the right to provide that service in the area. If there's enough for two, I cannot stop the second.
Right. What if there was a relationship? What if the said employee worked for a business? There was no agreement between that employee and the business. That person now goes out and does something in, let's say, a criteria of hasagas gvul. Is that a problem?
So if it's hasagas gvul, then I can get him for hasagas gvul in its own right, but nothing to do because he worked for me.
Right.
So, and it's very hard to stop someone through what you call hasagas gvul, is because most areas can support another shoe store, another clothing store, another restaurant, another law firm, so it's very hard. It would have to be like in a very small area, and that's where hasagas gvul plays itself out. There's another case where hasagas gvul plays itself out, but is really, according to many opinions, is not applicable in America, and that is when you are not a resident of the city. According to Chazal, if you are a resident of the city, you come first to try to get the income of the city. So if I'm a resident of Fort Lauderdale, so then I have a right to open up anything I want in Fort Lauderdale. If someone now doesn't live in Fort Lauderdale, is coming from a different city to come in to compete with me in Fort Lauderdale, he has no right to do that, because let him stay in his city and do business in his city. The reason why I say it's really not applicable in America, according to many opinions, This was applicable in Europe, widespread applicable in Europe, but it's not really in America because in America it works sort of the opposite. I mean, you could correct me if I'm wrong, but the way I understand is in America there's free trade, and specifically the Constitution provides that New York cannot stop a New Jerseyan from coming into New York, or vice versa. They want to promote free trade, so this goes against their law, and therefore there's no such thing in that second part of Hasagas bill in America. And if you want to extend it to NAFTA, as long as Trump keeps it alive, so then we could have it now extended to Canada as well. Canada cannot stop me and vice versa. We can't stop a Canadian coming in because there's a free trade act that we want to promote it. We do find this. Because then even it goes to the core of the issue, because the whole lumdis of Hasagas Gvul, according to the Rashba and many, the whole reasoning behind it is because we sort of exercise the power of the kingdom. Because it's really beneficial for the kingdom to keep it that way, because this way they could levy more taxes. If people are not stepping over each other, so they could levy taxes to the Fort Lauderdale resident and then to the North Miami Beach resident, whatever it is. Whereas if they'll compete with each other, it's going to pull away income out of the city. So then when the king wants to say, okay, Fort Lauderdale, you have to pay us X, they won't have the money because some of their money, some of the income was siphoned off to a different city. So therefore it was sort of to the benefit of the kingdom. But today we're the kingdom, which means the American government, is saying the opposite, that they feel it's better to have free trade, so then we can't exercise the Hasagas Gvul. And we find a similar thing in the Ottoman Empire. Go back 500 years, it's a Chuvas Marishdam who discusses this, and it says in the Ottoman Empire they came with the same thing as the American government, that they made a law that even though it's a very large empire, larger than America perhaps, and they made a law that you cannot block from province to province, city to city, state to state, you can't block them, and therefore the Marishdam said there is no Hasagas Gvul. Everyone is allowed to, because the government made a law. But anyway, we just sidetracked inside the subject.
What about Torah by Hasagas Gvul? It doesn't apply, right?
By Torah is not doing that, right?
There's no.
Yeah, you can open up as many yeshivas as you want, right? Right.
And identity of a business.
Like, what do you mean?
Let's say in this particular case, not to continue sidetracking, but in this particular case I mentioned, in the event that someone was working for X and then goes out and tries to compete, and let's say Hasagas Gvul doesn't apply, but the business he worked for had a very clear identity as to their business, their name, their logo, their institution.
He's not going to use their name. He won't use their name.
Not the name itself, but the entire mahos and look of their business model in every way, shape, or form.
He could perhaps copy that model, but he can't use the logo. That's their property. It's intellectual property, whatever it is. He can't use their name, but everything else, the idea of how to service a client, he could use, right?
It's a similar business name, not the exact same.
Style.
Well,
Style is what I'm
similar
referring to.
might not be.
Meaning if
Right, as
if
long-
100%,
correct.
if to a layman's person on the street, if they look at and they're completely confused because they think it's the other person because it's identical, that's the shiloh.
Identical in service, identical
No,
in
identical
name.
in name.
In name, no,
It's
that's
confusing as to who's
no.
who because it looks
So
exactly like.
that's the Namalkuzinina, that will be blocked, right? If you have a name, you just like
Similar,
spin.
not identical, then.
Well,
Okay,
that's
well, how
up
do
to
you
the judge to
identify-
Right,
decide.
how do you identify
Confusion.
that?
That's how it is.
Confusion is really.
Right.
Similar to the point that you're intending your target audience
Yeah,
to confuse it with the other
Yes.
building is really intentional, right?
That's
So
exactly what I'm
Right.
You have to
pointing
be
out.
careful about
Right,
similar.
but sometimes it's natural and it works to their favor. Like, let's just say, I don't know if anyone follows the like Yeshiva Hack, but there's a site, but there's a site called CBN. Anyone familiar with CBN?
It's a WhatsApp group.
WhatsApp group,
Yeah.
right? And a lot of people on there. Thousands of people follow this, right? Now, notice NBC, CBN. It's just the same initials inverted. It happens to be he's innocent because that's his name. That's his initials. It's Chaim. I forgot what the B stands for. And his last name is Nager. So he happens to be CBN. But it worked for him. So, but sometimes you have to know. I don't know how a judge would look at that one. Okay, so let's go back to here. So when we're talking about a non-compete,
Does the non-compete extend
same things you said to a non-disclosure agreement, that you won't share the secrets of a company with another person?
So that could also be a similar problematic. The only thing is, non-disclosure in halacha, even without the agreement, there could be a non-disclosure, because in halacha you're not allowed to share someone else's secret. So I'm less concerned about that, because if it is a secret, then anyway, according to halacha, he's not allowed to share that.
You have the-
Again, not always, but in many
But
instances.
if you, the secret holder, shares with the other person, this is a secret, and you are not allowed to share with anybody, is that enough, or you have to have a document?
Yeah, according to halacha, that would be enough. But it would have to be that it's understood as a secret. No, there's a law in Rav Hutner Zatzal.
Sorry, I'm a little late.
No problem. Rav Hutner Zatzal had a line. He said that a secret means, he had a sense of humor. He said a secret means that you only tell one person at a time. That's what a secret. No, but if it's a real secret, now let us close it. Yeah. So let's go back to the non-compete. So really, in halacha, we have a problem at how the deal. We're just talking about non-competes, how secular deals with it, and how halacha deals with it. So according to halacha, really, you can't ever create a non-compete, not because of the benefit of business or for the better gain of the community. No, it's not like that. It's just because it's nothing tangible to make it go into effect. So therefore, we come up with two different, similar, creative ways to make a non-compete binding. I wonder how the courts would look at it, but one way is like you had mentioned, what we do is we create an obligation, and it's a condition obligation, and that is, you owe me $1 million if you compete. If you don't compete, you don't owe me anything. I'm not telling you shouldn't compete. You have every right to compete, for sure. Go compete. But you should know, for every instance you compete and you don't cure it within 7 days, you owe me $1 million.
Many of the non-competes have such a provision. It's called a liquidated damages provision.
Right.
It's impossible to determine what the
Right.
damages will be, but if you compete, we all agree that it's going to be X dollars.
Right, so that is binding in the law.
How is that any different? You're still binding them to not do something.
No, I'm not. You could. I want you to compete. I'd rather you compete.
$1
Compete
million.
and pay me money. Compete, and the obligation is dollars, so that I could make a kinyan on. That goes into effect. What you're doing is you're creating a document that obligates a person that he owes $1 million with certain conditions. Only if he violates or breaches what our understanding. Fine. So what I'm getting him on is not to compete. I'm getting on is he owes me $1 million. Just like I can make a document, I owe you $1 million. I owe you $1 million on certain conditions. So I owe you $1 million if I compete. I want you to compete, for sure. Go compete. I'm not stopping you.
It's a simple try, basically.
Correct. That's how we do it.
But I thought you're not allowed to make, maybe I'm missing something. I thought you're not allowed to make a deal if it's not tangible. There's nothing coming from the fruits of my hand. So I can't.
No,
make
tangible means I have nothing that the kinyan could be chal on. There's no item. In halacha, everything is done through a kinyan, an act of acquisition. That's what a kinyan is.
I
An
gave
act
you
of
a job,
acquisition.
and in return for giving you the job, you're not going to compete with me. That's also.
No, because the non-compete is not an item. I could do in exchange of giving you a job, you give me your house. That I could do.
Yeah, but the theory
But here,
is-
there's no item. It's an action. It's not an item. So in halacha, you can't have an act of acquisition on something that's not tangible. It's not an
It
item.
is,
But money is.
It is tangible because I won't give you the job if you're going to compete with me. Why should I train you to be my competitor? Why should I let you know who all my customers are so you could go out and take away all the business from me? Why should I send you to school to get a degree so you could do blah, blah, blah? If I'm going to make that investment in you, you have to promise me you're not going to use it against me.
Right, so I understand the logic behind it, I understand the reasoning behind it, but in halacha, the only thing that can be binding is when it, how do you say chal? I don't know, when it, anyone has when it
I
rests
understand what
on
you're saying.
something.
Right.
It has to go on something. So if you're asking me not to cross the street, even if you have good reason for me not to cross the street, but you can't make an act of acquisition
Well, why
on
is
crossing the
that
street.
That's
binding?
backward looking.
Yeah, why is that binding? I'm giving you a job. I'm giving you an opportunity.
No, for
I'm
sure
giving
you gave
a
me,
salary.
for
I'm
sure you gave me
training
great consideration. But what you're asking in return to bind me not to compete, is an action, not an item. Right? There's no item. It's not dollars. It's not a house. It's not a table.
But neither is the training, neither is the
Right, no, that yeah.
exposure.
But
neither is-
all that is consideration. Consideration in halacha doesn't need to have something that's tangible. What I call that, I mean, an item. But to make something binding that it blocks me from doing something, there's no such thing. I could assign you an asset, that's for sure. But to say that I can't cross the street, that doesn't work. So therefore, we create this conditional note, and it's a very simple way to address this. And if I wonder how the secular courts will view this.
Well, I can tell you, a contract with a penalty clause is not enforceable. So if you're saying it's $1 million and it's not disproportionate to any damage, it's a penalty clause, and it's not enforceable.
Okay, but like
The
you
more
said, the
better it
liquid.
is for halacha, the
Okay,
worse it is for-
no, but you should know in halacha there's such a thing as that as well. And the penalty clauses don't carry weight in halacha either. It's called a nasmachta, and it doesn't carry weight either. But what you just said before helps because you called it liquidated damages. It means we are now assess from the get-go that this is the damage that's going to be caused. So once we have both parties admitting that that's the damage, so then that takes care of asmachta, because it's no longer a penalty.
Right.
It's a fair amount.
But the premise of a non-compete is that the damages are irreparable. That you can take away someone's business, you can take away someone's livelihood, you can take away someone's future earning capacity. How do you compute that in terms of damage? And that's why
So
the
you put
court,
liquidated.
it allows for an injunction.
Okay.
Because the damages are considered to be irreparable.
Great. So if you would put into an agreement liquidated damages, and if you violate this, you owe this penalty, how would the secular courts view that? Not a penalty. You owe this liquidated damages. Will the courts uphold that or not?
Yes, if it's reasonably tied into actual damages, the courts will
Great.
uphold that. But it doesn't give the party complete relief because it doesn't. Someone could say, "Look, you trained me. You sent me to school. So the tuition was $25,000. You trained me for the first year I worked there. I wasn't very productive. You gave me $50,000 in salary, half of which I was just learning. So for $75,000, here's your money back, and I'm going to go out and compete." No, that's the law says something different. But now, in the future, you could basically take away the goodwill value of the entire business. So therefore, damages are considered to be irreparable.
Okay, so then it works. So we're good.
No, it doesn't work.
It's irreparable, you said.
It's irreparable. So if it's irreparable, the only way to give complete relief is to enjoin the party from competing.
Meaning a halacha
So
is not gonna
you
stop
can't
the person
enjoin.
from working.
Right.
They're just gonna have to pay.
Right.
Under secular law, there would be, the court will stop them from
Okay.
competing.
Okay, in certain
Yeah,
situations.
generally for a period of time though, right? Not indefinitely.
Yeah, and it's limited, right?
Limited in region also.
It's a maximum of 3 years, or typically it could be a year to 3 years, depending on the circumstance. It's also limited by geographic area.
Right. Okay. Fine. So yes, halacha won't get to stop, but halacha will get. So if you make that liquidated damage penalty, we don't want to call it a penalty, but you make that liquidated damages high enough, that will be the
If it's high
deterrent.
enough, it then becomes a penalty.
But in halacha, we accept it if you have both sides agreeing that that's a damage. Because you just said it's irreparable damage. So if it's irreparable damage, so then it's never too much because he could be taking away my business. So it's really never too much, right? So that will work in halacha. And then, just to be safe, what we do is we add in at the end of the agreement what we call an asmachta clause, which is ways to work around how to make penalties binding in halacha, and we add that to the agreement as well. So now we have a conditional obligation, and that keeps him at bay. That keeps him to behave that he won't compete. That's how we deal with it.
Could you do it where I say I'm gonna acquire the rights to the employee's work for 5 years in exchange for.
It's hard. You can't. There's no such thing. You would have to hire him for 5 years, and then he's hired by you. But then you would have to give him a salary. I know it sounds to me like very
I'm saying giving
complicated.
him a salary. Okay, give
But
him a
his salary, maybe you don't
Thing
want.
is,
Maybe you don't want him. Maybe.
Well, you can.
You
pay-
prepaid the
it's your
salary,
final
by
offer.
paying him for that 1 year, you prepaid his 5-year salary, that's what you guys agreed. You say, I'm gonna give you $100,000, you're gonna work for me for 3 years. Even if you leave after the first year, you're still working for me.
Still
But,
only your
but if I
work.
work for you for the second year, then what? Then you're not gonna give me more salary?
No, that was it. Meaning that's really what the
Well, not true, because I work, if everything works well and I stay on, of course you can pay me another additional salary for the second year as well. Some people want to do is what Bob had mentioned, but it's not as a deterrent, is that they assess what the training value is, the cost to go to school and the training, and then they also say that the whole first year that you're here and we're giving you salary, that's just to be nice, because really you're not benefiting the company yet because you're just learning on the job, and they give a value to all that, and then they say, look, we're willing to waive that as long as you don't compete. But if you compete, then we're asking you to pay us for all that training and salary and schooling, etc. But the number is not going to be $1 million. The number will be maybe $250,000. So it's not as much of a deterrent.
How does the geographic factor that Bob just mentioned apply to the internet? Because the businesses are global, they're not limited to a specific geographic.
The courts account for that. If your business is on the internet, then you can't compete anywhere.
Right.
Anywhere there's an internet access, you can't compete.
Right.
It's the geographic area where the business is doing business.
So if it's on the internet, it's everywhere.
Everywhere.
That's because that's the same area, so to speak.
Got it.
Same, but in halacha, geographic area doesn't play a role. In halacha, we only care about how we could figure out getting that penalty to be binding. So once we got that, then we could do anything. I could create, with being creative, but if we could have a legitimate liquidated damage clause that's binding in halacha, then I can stop you from the entire America, the entire North America. I can, whatever it says, whatever the condition is. So if it's a conditional obligation, if you open up shop in Quebec, we'll get you for the $1 million too. I mean, it would be nice to do that if it's really not competing with you. Why are you being nasty to the guy? But in theory, it will trigger that
But that goes
obligation.
back to the premise. You're saying you have to pay a penalty if you compete. If you go to Quebec and we're not doing business in Quebec, you're not really competing, right?
Right, so depending, but we define the region usually into the agreements. Now, as a matter of practice, I do keep the region limited, of course, because why are you hurting this person for no reason? Like, you're happy where you are, your business is only in New York, so what do you care if he opens up in Pennsylvania? Like, well, what do you care? You're just trying to be nasty on him, you're just trying to choke him and, lock him up that he's stuck by you. So that I don't allow, but that doesn't mean halacha is allowed. Halacha allows it. I just don't want to be party to it.
One of the things I've seen with non-competes, one of the reasons for them is you could be more or less competitive with salaries.
Correct.
Because you don't have to, if the guy can't go someplace else,
Correct.
he's stuck with you, and so you don't have to pay him, say, a market wage because he's not a member of the market.
Right. Yeah, you have more leverage on the guy. In other areas, it's just that. You could ask him to do more things. It's true. It sometimes can create an unhealthy relationship. That's true. But this is how we deal with it. So there is a workaround. Most things in halacha, I'm sure they'll have the by secular also, where you could have a workaround. So there are workarounds. It's just you have to know how to do it. But it's typical. So I was going back that we had this person on Friday, Floridian, who asked me, he had a non-compete. So I asked him, let me see your non-compete. He pulls it out, and sure enough, it was a secular non-compete. So I say, look, I can't speak for the law, that you have to speak to a lawyer, but I can speak for halacha. Halacha doesn't recognize a regular non-compete. So it won't be binding. That's why it's a good idea, if you're talking about people who are following halacha, that they should make sure that their documents are done up in halacha. Because otherwise they're going to end up now, like this guy now will most likely compete because he got a green light according to halacha. And had the employer done it right the first time, initially, this person would not be competing with him. He would have saved competition. I mean, everything is bashet. Hashem wants him to compete.
The intent doesn't matter.
Who?
The intent, both of them agree that he's not going to, the employer didn't want to compete. He agreed not to compete.
Right, so intent doesn't really, intent is no like recourse in Bezdin for intent. It means what we call is mechusar amana, means we're going to look down at him that he's not trustworthy and he's not doing the right thing going back on his word. But in this particular instance, it was a little unique because there was a total misunderstanding between the parties. That means the employee thought that he was entitled to a certain amount of compensation. He showed me the document. Again, I didn't read the entire document. He just showed me that paragraph which discussed it. It seemed that he was correct. The employer had a whole different understanding of what that was. So then there was a total misunderstanding. So you can't hold me to my commitment if I did it under a certain understanding. I thought, yeah, I'll make that commitment if you pay me this as a salary or this as compensation. Now you're telling me you had a different idea, so then that's it. So you're basically ripping up this contract. You're saying that there's a misunderstanding here. So then don't hold me halfway. Oh, I'm not going to pay you the salary, but you still have to be bound and not to compete. That wouldn't be fair.
How does it work if, and under halacha, because in the secular law, if the employer breaches the contract, the employee is not bound by the non-compete.
Okay, so that will work in...
Right, is also in halacha the same?
There is... Yes and no, and I'll explain. In halacha like this, that if the contract, there was a meeting of the minds, there was no misunderstandings, and the contract started off being binding, and just later on, one side is not keeping his part of the agreement, that not necessarily undoes the contract. On the contrary, go enforce the agreement and make sure that both sides keep to the agreement. Two wrongs don't make a right.
Okay,
But here, where there was a misunderstanding in the initial contract, so that undermines the whole validity of the contract, so then you could throw out the whole contract.
Well, okay, but, that's, I think, similar in secular law, but in under halacha, let's say the employer, for one reason or another, doesn't pay the employee wages or a commission or something like that, can the employer still enforce the non-compete and say, well, now you owe me $1 million because you want to compete?
In halacha, yes, you can still enforce it, but the employee could sue the employer for wages. Pay me
Yeah, but
my
he's gonna
wages.
say, look, I had to compete because you weren't paying me.
You don't have to go into 1,000 different industries to go into.
I know.
You don't have to stay here, but if you have a time on me that I'm not paying you your wages, great. So sue me and I'll pay your wages. If so, the Bezdin decides. But two wrongs don't make a right. Just because you're not keeping your side, that doesn't mean I don't have to keep my side of the deal.
But you're causing me to not keep my side because you're not paying me for my wages.
Right, so the employee could sue for $10,000 in back wages, and the employer could sue for $1 million for competing.
If that's how it's structured, I don't know. Well, in secular law, if you create liquidated damage clause like you discussed before, which is upheld in court, what would be in that situation where the employer, let's just say, wasn't paying wages?
The employee is released from the non-compete.
Oh yeah? Wow.
Not a well-written.
If it's a material breach, that strikes to the heart of the contract. Not any breach, but any material prior breach will excuse.
So basically, two wrongs make a right.
It's one wrong is causing the other wrong. And the only reason I'm now going to have to do this is because you breached already. So now you're going to hold me to the contract that you don't hold that has validity and
No, maybe he owes validity, just for some reason he's not paying. He has no money. I don't know.
The concept is that the breach, the material breach that goes to the heart of the contract, destroys the validity of the contract. So if the validity of the contract is destroyed, how can it be destroyed and then at the same time enforced? That's I think the theory.
His obligation to perform is considered to be dependent, it's it's a condition, it's conditional on the other person not materially breaching the contract.
If it be written like that, I
Even if
agree.
it's not written like that, when it's a
It's
material
understood.
breach,
It's
that's what
understood.
they say, that when it's a material breach, it goes to the core of the
What if it's
contract.
written the opposite way,
And you
where
can't-
a breach by one party does not relieve the other party of its obligation of agreement?
I've never seen that in the
Well,
contract.
Right, they don't put that clause in?
The consideration for the non-compete is payment. If if they didn't give him the consideration, then he's not entitled to enforce the non-compete.
So you're saying that it's in essence, it's implicit that it is conditional.
Yeah, I think
Okay,
it's
but-
the consideration. for the
But usually,
non-compete.
is it consideration that, or is it only consideration of $10 and like how do they
And
write?
other good and valuable considerations. It doesn't have to be explicit in the contract.
Why is it not like, being that in American, in the secular law, a breach of contract is, the remedy for that is damages, right? So if I make a contract, why isn't it a regular non-compete structured in a regular way? Why, implicit in that obviously is, if you breach, the remedy is gonna be damages, potentially an injunction, but damages, let's say. So why don't you then say they were basically agreeing to, it's not a set dollar amount, but they were agreeing to damages if you compete.
So you would have to write that.
Why-
Because
why
they
do you
weren't
have to
doing
write
that. They
It's
were agreeing.
obvious we're not-
No,
we're not
because
agreeing
that's
to
what
something
the
like that
that's what
that has
the
no teeth.
that's what the court will do because I damaged. Because since I had an agreement, so there's a given that there's agreement in place, and then I breached that agreement, so I damaged you by not following the agreement. So now we're going to get you for damages. But we have a problem. We lost out on the first. You lost out on the foundation. If the agreement itself is not binding, so there's no damages because I didn't mess anything up because the
But
whole
an
agreement's not
agreement
in
is
place.
never enforceable if there's no way for it to be enforced, right? In other words, if there's no damages whatsoever possible to come out, it's not enforceable anywhere. Like, you can't enforce an agreement. An agreement is only an enforceable agreement if the court could do something to remedy a breach. Otherwise, it's not an agreement. So what I'm saying is when you enter into a contract with someone, what you're saying is we're agreeing that the court is going to remedy this breach by damages. It's like built in, it's understood. So maybe we're not putting a dollar amount, but that's what we're signing to. We're not signing to a piece of paper with no teeth. We're saying you're not going to compete, and this is a legally binding contract, meaning that if you do compete, the court is going to remedy that by assessing damages.
Well,
So
not
the
to
number's
be-
not, or maybe
They're
maybe
not
an
He's saying
additional.
there's no right to begin with, though. He's saying
Huh?
there's no right.
Yeah, but he's trying to
What I'm saying is,
argue
like, it's
that it's
built
as if
in.
it's already written.
Right.
I mean, let's say we would have written into the agreement that, and if you do compete, we get damages, but it's an unknown dollar amount. I don't know if Halacha would recognize that because in Halacha, you can't be, I have to think about it because you really can't obligate yourself to not a specific number. I can't just say, I owe you money and we'll figure out how much.
Or the court.
It has to be,
You'll be
How-
bound to how much
How's
the court
that different
decides.
than any other breach? If you breach the contract and I have damages, we're gonna go to the, Beis Din, or we're gonna go to court, and we're gonna compute what those damages are. How's that different than a non-compete?
because that is that when we have real damages, so then of course a Beis Din will compute what those damages are. If I break your window, Beis Din will compute how much your window cost and how much the damage was. But here, the whole basis to start off is this agreement. If this agreement is not binding in halacha, because you can't bind something that's not tangible, it's such an action, so then there are no subsequent damages. His argument just is as if I wrote and as if I was already obligating myself to the subsequent amount that's going to be assessed in court. That's your argument. Not because it's really damage, because it's really not damage, it's not halacha, because this is not binding.
Why?
It should be binding.
No, but I'm saying halacha is not binding. The not to compete is not binding in halacha. So, and if I breach that, I didn't do any damage because it's not binding in the first place. If I break that window, the only reason why I owe you money is because the window is yours. But if the window was never yours, I don't owe you any damages. Well, if the non-compete was never yours, you had no right to stop me from competing, so there's no damages if I compete. But and the argument is, but it's as if I made a dollar amount of obligation, but there was no specific amount, and you can't obligate yourself to an amount that's not specific in halacha. I can say I owe you money, but we'll figure out how
But
much.
if you create a formula, let's say, you say, if you take two of my clients, these two clients made X amount of money, and we're gonna do that, you owe us 50% of that, something like that.
So that's what basically
So
we're
it
doing
doesn't have to be a
anyway.
specific
So
amount.
that's what I'm
It
doing
can be-
anyway. I'm making conditional. We
you
liquidated
have to do
damage,
that.
and I'm going to make a specific number for every instance that you compete is $1 million liquidated damage
The formula
obligation.
wouldn't work?
You could do a formula too.
Well,
As
as
long
long
as-
as it's something
but
that
it's an
kind of-
obligation. It's not. But you have to be careful. You're not doing it because it damages. You're doing it because it's an obligation we create, which is fair compensation for what you're causing me in terms of a loss.
But what you're doing really is you're substituting one damage regime for another. Because under secular law, the damages would be, if you're gonna go by monetary damages, like Moshe is suggests, then it's a difference between what I would have earned had you not competed with what I did earn because you competed. That's the difference damages.
So-
What you're saying is, no, that it's better to say in advance what the damages
Right.
will be.
Let's create a liquidated damage amount, and that's the obligation we have, conditioned only if you breach that one this thing.
But the unknown of what damages are gonna be is the case of any contract. If I have a lease and I decide, you know what, I'm gonna throw this tenant out because I can get a tenant to come in at a higher dollar amount, then the difference is what the disruption to the tenant's business. How much is it gonna cost the tenant to get different space? How much business is gonna lose while he's looking for space?
But the tenant had a right there, the tenant.
You see, there it worked, because in Halacha we could also assess damages in that case, because there was a right that the tenant had, that you messed up.
You're trying to
so
create
you
the right after
damaged
the
that.
back.
But here, if we can't get the first base, there was never anything binding that stopped you from competing. It's like that window didn't belong to you yet, and now you want to get me for breaking the window. It's not yours. First establish the window's yours, and then you can get me for damaging that window. You can't, the not crossing the street, the non-competing was never yours, because it was never binding in halacha. So you can't get me for damages for competing. But we could create a conditional obligation that we could do.
I understand.
So real quick, we have in, I guess if we're doing a loan, we have the loan documents, but then we have the heteriska to provide for Jewish law. So is there a way where we can have a non-compete and then have your agreement where if you do compete, you pay me $1 million? For
Yeah, you could do that, but we're going to have to have, and the parties have to agree that there's a liquidated damage penalty. We don't want to call it penalty, but a liquidated fair value with parties agree, and all the lingo, and that we could do, and then we do that. Yeah, we do that. We make non-competes for people all the time.
But do you have a parallel English,
In English, we do it in English.
What I'm saying, a parallel American law document as well, that they sign both documents?
No,
Sign both.
usually it's only in one, but if we could do both, it's not a contradiction. It's just the parties have to agree. Try sitting down with an employee and telling him, you know how many times I did this? I'm sure you did. I've done this so many times. Employee, sure, I'm going to write a non-compete. Okay, fine, and I draft one and I put in that there's a penalty. Penalty? I'm not signing this. Wait, you just agreed that you're not competing. Yeah, but I'm not doing this. So you see that this really wasn't Gmir's das. It wasn't really full intent when he agreed to this non-compete. But when he sees the dollar amount, that shocked him, right? So if your employees are willing to execute that, great.
Well, do you have to use the word penalty, because that?
We don't
creates
use a penalty. We don't. We use a conditional obligation,
Okay.
and it's liquidated. It's fair and.
I think his question is: is it something that you have a standard thing that you have that everyone, or is this custom made for each individual
No,
case?
it's custom made only because we change the numbers and we change the terms and the length and the duration and the region. But we have a boilerplate, yeah, and I could share with you, and then you'll have to change names, region, time, dollar amount, etc.
So in the
Time to cure, we give 7-day time to cure. If you want to do less, more, whatever it is.
My understanding is in the heteriska has to be, if there's a conflict between the loan documents and the heteriska has to be.
Correct, it has to be, because there is, by its very nature, it's a contradiction. Because the loan document is a loan, and Hetiska really is a partnership.
Right.
That's what it is. So we know from the get-go it's a contradiction, and that's why certain banks refrain from engaging in Hetiska, because they believe, maybe rightfully so, that it goes against the FDIC, because they can do what they want, they're regulated, and in regulation, a bank is now entered into a partnership. Strict reading of a Hetiska, it is a partnership. Certain states, like perhaps Maryland and others, understand what Hetiska really is, and they allow it. It's allowed. But strict reading, we know there's a contradiction from the get-go. So that's where we have to have that Hetiska is supreme and reigns.
So in this situation, we had the non-compete and the halachic non-compete.
That's not a contradiction. No, because what you're doing is creating an obligation not to compete, and then you're going to go after them for damages for breach. And I'm creating a conditional obligation. Now both are true. Whatever you could win on, both are true, right?
Well, is there an issue with going to secular courts to enforce non-compete that halacha doesn't recognize?
Yeah, then there will be an issue
So I'm
because
saying, so then it really matters where you're going to enforce your non-compete.
no, if halakha doesn't recognize it, and you're dealing with two Jews, and you have a problem,
Right.
because then he's violating halakha. Means I'm stopping you from competing when, according to halakha, I have no right to do so. So
when-
really, I'm interfering with your business now.
So when you have two people who are going to follow what halacha says, then you don't need the secular non-compete portion of it because. You're not
Yeah, but
gonna
it would be advisable to get that. I mean, we incorporate it, but it would be advisable because just in case they are moira heta, we'll call it.
Okay.
And when it comes to it, they all of a sudden want to resort to the secular court. And
you're
I
saying-
advise that with
you're saying
everything.
And they won't pay, they refuse to pay and they're.
Right, I advise it with everything. For example, I think we discussed in the past, a number of years ago, wills, right? So there are ways to make halachic wills, but I tell everyone, I'm not going to make you a halachic will unless you make a secular will. I'll make an addendum to the secular will to make it binding in halacha, but I don't want any ear to decide that it pays off to not follow halacha and just go with the secular law because it wasn't done properly. So I want to make sure we have a secular will in place and halacha. Same thing here. You could have a secular non-compete and a halachic non-compete. Like I explained before, halachic non-compete, if it's done right, actually could be more broad than the secular, because secular, the courts like to throw it out, limit the amount, the time, the region, etc. In halacha, it will be binding. But I could, if you send me an email, I could send you what a typical non-compete looks like.
Is there a difference in halacha between how long the person is working for him? Because you're doing a non-compete, so it doesn't. He can work for him for 1 day and then he.
Never, yeah.
But
What about how long it
in
lasts?
secular law, would it make a difference? How long he
No,
works for?
once you sign, you sign.
But if your whole claim is that
It
you're.
could not be reason, it may not be reasonable
Reasonable,
at that
yeah,
point.
maybe. But how long would it last, the conditional thing? Forever?
Whatever term you put in.
Yeah, but you could in theory.
You
say
could. I don't
last-
do it because I don't think it's nice. I don't think it's right. No, really. I mean, maybe because I'm influenced by the secular. No, I don't. What are you stopping the guy for 10 years? He's not your eved. He's not your slave. But what do you? All you need to do, really, if you think about it, if you stop a guy for 2 years, he's done. He's not competing with you because if he goes out of the industry for 2 years, he's now selling ice cream. He's staying in the ice cream business. If the ice cream business fails and he wants to go now back into this business, he really has to start all over again. He lost the context. He lost so many things changed already. It's going to be hard for him to get back in. He has a real disadvantage.
What about another situation? I buy a business from someone, and the business has a certain amount of goodwill. I'm going to pay a lot of money for that business, and one of the conditions is that you can't go out and set up a competing business because you have a following with the clients, you have
Sure.
the know-how to do it that I'm going to acquire by buying this business. After the transaction is finished, and how would that work in terms of halacha for stopping?
Same thing. You would have to make sure you have a proper halachic non-compete in place. In that specific instance, one could argue, let's say you didn't have a proper halacha, and now the seller would like to renege on that agreement. There, I could hear that maybe that's a material breach, and that could undo the whole sale. Because I only bought the business with a certain understanding that you're not following. There, I understand that might be from the get-go, this is not the deal I had.
You didn't sell the business if you're continuing to do the business in another name.
Yeah, I mean.
Right, correct, that's what I'm saying. So then it could be that it's grounds for what we call a mekaktois, and we just unravel the entire sale.
That wouldn't be fair to the buyer because the buyer bought something that the seller essentially could undo simply by breaching the
Right,
contract.
it's not, if the seller can't force the mekaktois, it's the buyer could opt to do it. But in economy, he's at a disadvantage. If he opts to do mekaktois, then everything's unraveled and he's back out on the street. And if he keeps it, then he has a problem that the seller is now competing with him. So yeah, there you should try to get it halachically binding non-compete for sure.
Well, probably in that case, the dollar amount could be much higher because it's easier to justify.
Yeah, sounds good. So yeah, we could deal with it, and that's we live in Gola, so we have to figure out how to make secular law conform with halacha that we win on both accounts. Okay,
Thank you.
my pleasure. Hope you enjoyed lunch.
Yeah, thank you.